Let's go ahead and get started. Welcome, everybody, to what I call Lunch with Liz. Um, I'm Liz. I'm your hostess for the next, sometimes we're here a half hour, sometimes we're here the whole hour or more. So, however long it takes for you to have your questions answered is how long I'm here. Usually, the first question I get is that really your last name, or did you just make it up? I promise you, I did not make it up. It was my dad's name, my grandpa's name, and generations before that. Um, if I made up a name, I probably would have made up something else because Moneymaker gives me a lot of trouble sometimes. I am an attorney here in St. Petersburg, Florida, but I service clients throughout the state of Florida. So if you're on the call and you don't live in St. Pete or Sarasota or Bradenton or Tampa or Palm Harbor or Dunedin or somewhere right around St. Pete, don't worry because we service people everywhere if you decide that you would like to work with us. What we do is a variety of estate planning services. For example, wills, trusts, powers of attorney, living wills, probate, trust administration, and Medicaid planning. And I do lunch with Liz's on topics surrounding all of those things all throughout the year. Why? Why do I do lunch with Liz? Because I found that there were so much misinformation out there. And I could have been, just like Mrs. Kelsey or Joe Rogan. I could have had a podcast like everybody else. But why I chose to do it this way is because it's an interactive way and you can ask questions. If I say something and you don't understand it, or you want to figure out how it applies to you, you have a way to ask questions here and get clarification. And I think that is super important because the law is just gray. It's a lot of gray area. It's a lot of it depends. So just having a podcast on a topic, I didn't feel like it was sufficient enough. So how it works is this. I have some stuff to say because I'm a lawyer. That's what we do. I'm going to say some stuff. There's a myriad of ways that you can ask questions. If you're familiar with Zoom, there's a hand up icon. You can use that. And my trusty right-armed woman, Vicky, who's on the Zoom here, she'll notice you and let me know that you have a question. The other way is the chat function. You can type your question in the chat. It's best if you type it to everyone so everyone can see the question. But even if you just type it directly to me, I will be reading your question out loud. So just so we're clear, there's no attorney-client privilege or confidentiality on anything that you would ask on this particular format. If you want an attorney-client privileged communication, then you would set up a consultation with me, and I'd be happy to set those up complimentary for anyone who's on the Zoom today. The most important thing I want you to take away, though, is there is a reason you came today. There is a reason that you clicked on my link and you signed up and you actually got the Zoom link and you clicked on it and you're here. So if I don't answer your question, that's bad. Okay. I want to make sure that for whatever reason you came, you get that question answered. So if we end up zigging when I intended to zag, because zigging answers your questions, and that's what we're going to do. Okay. Um, I can make this pretty flexible if that's what we need to do. So let me get started. Quick caveat, I'm just getting over a cold. So if I go off screen or on mute to sneeze or cough or something, that's why. So I apologize for that in advance. So let's get to the meat and potatoes of all of this. Estate planning for the community, our community. What we're going to talk about today is estate planning documents and things that you can do to protect yourself, whether you're married, whether you're in a same-sex relationship without a marriage certificate, or whether you're single. The entire focus of this Lunch with Liz is not going to be on same-sex marriage, but I want to talk about it real quick. I am not giving you any different advice today than I would have on November 4th or November 1st. Okay. It's the same advice that I would give you. In my opinion, the threats haven't changed. The threats have always been there to same-sex marriage. Um, let me just give you a quick background on same-sex marriage in Florida. Same-sex marriage in Florida is actually banned by a Florida statute that is still on the books. There is a current statute that bans same-sex marriage. That statute was ruled unconstitutional in January of 2015 by a Miami District Court judge. For whatever reasons, Tallahassee decided not to appeal that decision, and Florida started recognizing same-sex marriage and issuing same-sex marriages, marriage certificates that anymore. Fast forward to 2022, President Biden signs the recognize sex marriage, and you move to another state that doesn't, that state has to recognize. I say all that because if Obergefell is overturned, I'm going to go out on a limb and say I don't think it will be. But if it is, Florida was basing its issuance of same-sex marriage certificates before Obergefell. So there is Florida precedent to keep same-sex marriage. But even if Florida didn't, I don't believe that it would be retroactive. It would be any future marriage licenses wouldn't be issued. Florida would have to still recognize marriages that were entered into in other states that recognize same-sex marriages due to the federal statute. That's a lot to talk about, and I hope you followed. And I'm going to go out on a limb and say I don't believe Obergefell will be overturned because it is different than Roe v. Wade. I was wrong on Roe v. Wade too, though, so I'm 0 for 1 so far. But there is a different, in the law we call it the reliance. There is a different reliance on Obergefell than there was on Roe v. Wade. Their IRS and Social Security and the military all now recognize these same-sex marriages. People are getting married with the expectation that same-sex marriages will be recognized. So the logistical fallout of overturning it is a lot more. And that's discussed a little bit in the decision that overturned Roe v. Wade about why it is different. Again, I'm 0 for 1, but I don't think it will be. But we're here today, and I'm giving you the tools that I believe that we have in place right now, that even if it is, I want to show you how we can protect ourselves as members of the community, okay? And reason that's important is because a lot of times our chosen family is not our biological family, either because they have chosen not to keep us as a part of the family, or we've made that decision on our own. And if you don't have these things in place that I'm going to talk about, your biological family, whether you want them to be or not, will be involved in receiving your assets when you die and making medical and financial decisions for you instead of your chosen family or your chosen partner. So let's get started. When you hear estate planning, a lot of people roll their eyes and like, oh, I don't have an estate. I don't need to worry about estate planning. But estate planning is way more than just I'm a millionaire and what am I going to do with my money? It has to do with your healthcare decisions, your financial decisions while you're alive, what's going to happen with your real estate, what's going to happen with your investments, your retirement accounts, what's going to happen to your minor children if you have children, and last but certainly not least, what's going to happen to your pets, the pets that a lot of us treat as if they were our children, because they are, right? A good estate planning attorney is going to be talking to you about all of these things. They're not just going to write you a will and ship you out the door. If you go to someone like that, they're doing you an immense disservice for sure. So let's switch now and we'll talk about some of the documents that are important to ensure that you're protecting yourself, your partner, your spouse, your children, and your chosen family. The first is a proper will or trust. And I'm not going to get into the differences between a will or a trust and what's appropriate. I do a lot of Lunch with Liz's about that topic. So if you're curious about that, stay tuned because we'll do another one in 2025. But bottom line, what a will does, it lets you decide what happens to your property. And by property, I mean your house, your condo, your bank accounts, your investment accounts, your personal property. What happens to that stuff when you die? What happens to your minor children? Who gets custody of your minor children when you die? Who gets custody of your pets when you die? Who's going to take care of your pets when you die? It lets you designate all of these things. And without a will, guess what? Florida law dictates. And essentially what Florida law says is if you don't have a will and you die, if you're married, most things, but not all, would go to your spouse. If Florida recognized the marriage, would go to your spouse. If you don't have a spouse, it would go to your children. If you didn't have children, your parents. If you don't have parents, siblings, and then it goes on from there. So if you don't have a plan, Florida law has a plan for you. Um, and let's kind of go into some of those scenarios because I think that makes it a little bit easier to follow. So let's say that you're married. So let's say Tracy's married. I like to use Tracy as an example. She's I think she's listening in today. They say Tracy's married, but Tracy has children from a prior relationship, right? And Tracy owns the house that she and her spouse live in. Tracy doesn't have any documents because she didn't come see me to take care of them, and she dies. So she owns the home, but she's married, but she has these children from a prior relationship. If she doesn't have documents in place that say that the house goes to her spouse would get a life estate in the house, and the house would ultimately be owned by Tracy's children from the prior relationship. I've seen this happen multiple times in my practice, and it's pretty devastating for the surviving spouse to not get what they thought they were going to get. Thought they were going to have the house to retire in or to sell and move away in, and that they don't. So that's the biggest exception to the spouse not inheriting everything when the other spouse dies. So if you're in that scenario where you're the only one owning the home and you're married to someone, you need to definitely get your documents in place to make sure that they will inherit the house if that's what you want to have happen. The other scenario I see happen a lot is long-term partners, but only one of them owns the house. Same scenario, right? If that owning partner dies, the surviving partner is not going to get anything. And the family will get it pursuant to Florida law. Family comes in, sells the house, takes the bank accounts, all of that, and then that surviving partner is left with nothing. So those are two big reasons why you need to have a proper will and or trust plan in place to ensure that your spouse or partner is taken care of when you pass away. It's also important to have an appropriate will or trust if there have been a change in pronouns or gender identification. There's not a lot of case law on this yet, but I don't want to be the case law. So I make sure that we are very clear in our documents that it doesn't matter how we're going to refer to someone, that all the bases are covered so that there's no one can come in and say, oh, that's not the person that should inherit because that's not their name or that's not their gender, to make it very clear. The next thing to think about, the next document to think about when you're doing proper estate planning is your deed, the title to your property. How do you own your real estate if you do? I can't tell you how often I have clients come in and say, well, we own it jointly. We're both on the deed. Well, just because you're both on the deed doesn't mean you own it jointly. It's important about how it's written on the deed. And let me tell you a sad story. Had long-term female couple that their retirement plan was real estate. They bought, I want to say, about a dozen houses in the Pinellas, Hillsborough area. And so they mainly had rental income from those properties. Both their names were on all the titles. But it turns out that they were tenants in common. And what that means is that one of them owned 50%, the other one owned 50%. They had no documents in place. One of the partners dies. Well, because they didn't own them jointly with rights of survivorship, they owned them as tenants in common. The the deceased partner's share all went to her estranged daughter. So now this long-term partner who had no relationship with this daughter was now a co-owner of all these properties with her. It was definitely not their intent, but they thought because both their names were on the title that they both owned it, and when one died, the other one would get it, and that's just not the case. Um, what I would say there is, if you don't know, honestly, I would look at it for you for free. Just send me your title and I'll tell you. You can always go to most real estate agents understand that. Of course, title companies understand that. Real estate attorneys understand that if you just want to make sure that you have it correctly. I'm going to jump back to what I said before on the other topic about the will and making sure if only one partner owns it. What I don't want you to do is then just add someone's name to the deed without getting some guidance on that, because there could be tax implications if you're not married, just adding someone to a deed. So you definitely want to get legal advice about that. So I'm going to give you a little warning about doing it that way. All right, moving on. The next document that you need to protect yourself is a durable financial power of attorney. I said before that a lot of my clients come in and they think estate planning is just, hey, what happens to my stuff when I die? I want to take care of my stuff when I die. And that's important. And we certainly, talk about that and make sure we understand their goals and concerns and all of that. But in my 20 plus years of practice, what I have found the most important is planning for short of death. What happens if you can't make medical decisions for yourself or financial decisions for yourself? And that's where the durable power of attorney for finances comes in. That lets someone make financial decisions for you in the event you're not able to do so for yourself. It is not true that just because you're married means that you can make financial decisions for someone else. If you're a joint owner on an account, can you make some decisions? Yeah, probably. But you can't sell a home, refinance a home, and do a lot of other decision making without a power of attorney. If you don't have a power of attorney in place, then the law steps in again, and we have to create a guardianship. And you might have seen a lot of guardianship movies out lately that show how the courts get involved, judges get involved. Nobody wants that. It's a lot of money and it's a lot of oversight by a judge. And typically, if there's no paperwork that says who you want to take care of your finances, the judge is going to typically side with family, side with parents, side with siblings over a long-term partner. I had a guardianship case in Sarasota where I represented the partner of a woman who got dementia, and he wanted to be her guardian, but there was no paperwork in place where she named him as wanting as her wanting him to be that, or her wanting to be her power of attorney. So we had a 3-day hearing where her family wanted to come in and be her guardian. And we argued that he should be, and we showed how they had this long-term relationship, and the judge sided with the family. Now the family was only interested, obviously, because there was money involved, but it was a devastating case. Long-term partner did not get to continue to make decisions about his partner because there was no documentation in place. So if I had to step on my soapbox and say the single most important document to have is a properly written, properly executed, durable power of attorney. The next document that I'd highly recommend is your medical directives. And that's an umbrella term that I use for 3 things. One is your living will. That lets you say how you want to be treated at the end of life. Do you want life-sustaining measures? Do you want the plug pulled? That type of thing. The next thing is the healthcare surrogate. That's like your medical power of attorney. Who gets to make your decisions medically if you can't make them yourself? Who gets to be in the hospital room? Who gets to talk to the doctors? Who gets to understand your diagnosis and your prognosis? That's who you designate in your healthcare surrogate designation. And then the third thing is the HIPAA waivers, ensuring that you've included that your spouse or your partner or your friend, whoever you're designating, you're waiving all your HIPAA rights so that they can know your healthcare information and they can make those healthcare decisions for you. Because without it, again, there is a Florida statute that says if there's nothing in writing, it is going to then default to family and not to biological family and not to potentially the person that you actually want to make those medical decisions. So, the moral of the story is simply that if you're an unmarried couple, you simply must have estate planning to protect each other. Otherwise, there's not a lot you can do. I do another lunch with Liz where I talk about some things you can do on your own, such as pay on death designations on checking accounts, transfer on death designations for investment accounts, ensuring beneficiaries are up to date, those types of things. So there are some things that we can do outside of doing a will, but I always advise people, most estate planning attorneys offer a complimentary consultation. Just go in, you're gonna think about things you might not have thought about by talking to someone who does this day in and day out. If you're single and you don't want your biological family to get your assets or make financial or medical decisions for you, you must have your estate planning documents in place. There's no other way around it. If you're okay as a single person to have your kids or your parents or your siblings inherit from you or make your decisions, then you might be able to get away without having an estate plan. But more than likely, there's some hole there that you need to have stopped up with some sort of estate planning document. And then if you're married, and we want to make sure that even if same-sex marriage is overturned and is retroactively annihilated, you want to make sure that we've done everything possible so that in the end you're treated as if you were married in the extent of inheritance, financial decisions, and medical decisions, then you're definitely going to want to have these documents in place that we've talked about here today. I am going to see if we have any questions. I don't see any in the chat yet. Oh, I do see one. Um, so we have a question that says, this is a great question. Is our property title a married couple as tenants by entirety safe? We weren't familiar with that term when we moved to Florida. Ohio's option for married couples was joint tenants with survivorship. Okay. So tenants by the entirety is like joint tenants with rights of survivorship. It means the same thing in that if you're married and one of you passes, the house would automatically become the survivors. Tenants by the entirety has other benefits as a married couple regarding creditor protection and regarding bankruptcy and that kind of thing. So on the one hand, tenants by the entirety is better, right? It has more protections. On the other hand, you can't see my hand. On the other hand, um, if and I don't believe this will happen, but if your marriage is invalidated, then you're no longer tenants by the entirety. So if that happens, I would recommend that you update your deed to say joint tenants with rights of survivorship. But so long as you're married and Florida recognizes marriage, I would keep it as tenants by the entirety. If your deed says uh, Sally and Susan, a married couple, that means the same thing as tenants by the entirety. Or if it says Johnny and Paul as husband and husband or something like that, that's the same thing as tenants by the entirety. So that's still good. I'm just saying red flag if marriage is invalidated, you're going to want to update those deeds to say jointly with rights of survivorship? Great question. Um, I'm going to pause and take a little drink if anyone else has other questions. Feel free to come on video, have a chat. That's why we do it the Zoom way and not the podcast way. Okay. Mhm. So while you're thinking about maybe if you have questions, let me just kind of give you an idea of what it would be like if you decided to go talk to a lawyer. Typically, you're going to call or contact them via their website and get an appointment. Most, not all, estate planning attorneys do a complimentary consultation. It's an interview, right? You're interviewing me, I'm interviewing you. Are we a good fit? Can I help you with what your goals and concerns are? Assuming that's the case, if you're coming to me, we construct a plan to accomplish your goals. I always say, let's find out a way to get where you want to go in the simplest, most cost-effective way possible. If you don't need a trust, you shouldn't have a trust. You shouldn't complicate your life that way. But if you do need one, then that is the simplest thing that you can do. If you have a special needs child or you're trying to provide for a minor child, oftentimes a trust is the only way to go about that. Or if you have property in another state, for example, a trust typically is the only way we can avoid probate with that property in another state. So those are the types of things the lawyer is going to talk to you about. Some lawyers do fees by the hour. I do a set flat fee based on what I do for you. And you know that fee before you hire me. If you hire me, then we draft documents. You get a lot of boring legalese to review. Once you're comfortable and you understand and everything looks good, you come in and you sign things properly. And I say that because so many times I get wills where someone has died and we have to go now try to enforce the will that they weren't done properly. Someone got it off the internet, or a friend did it or copied somebody's, and it wasn't signed correctly, and that can completely invalidate a will. So we want to make sure every T is crossed and every I is dotted. And then you go home with the plan, and then I bug you every year to make sure it's still up to date. No, I don't really bug you, but I remind you to keep it up to date. Um, a lot of times we'll have people who'll bring in an estate to administer because someone has died and everything is out of date. Beneficiaries are from relationships 3 times ago. So it's nice to have a reminder to always update things when life events happen. Either I was really good today because I don't see any questions, or I was so bad that you don't even know where to begin. So if you don't have any more questions, I'm going to give you back half hour of your life. What I also offer is if you're just shy and you just don't want to ask it in front of everybody, I stay on for a little bit afterwards. If you just want to have it wouldn't be a confidential consultation, but if you just were too shy to ask the question in front of everyone, I stay on a little bit after. So if you don't have anything else, you are dismissed. You are free to go. But if you have questions, Holden, Holden says, "Oh, we have some other questions." Sweet. Okay. Holden asked. Holden asked, can you just tell us more about gay marriage in Florida? What happens if marriage is overturned? Like more than what we talked about at the beginning, Holden? Because I'm not sure I know any more than what I talked about at the beginning. Um, so while you answer that question, I'm going to answer Christina's question about ladybird deeds. Um, so again, in promoting my other lunch with Liz's, I do typically throughout the year probate avoidance uh, seminars as well. So what what a ladybird deed does, it's also called an enhanced life estate deed. is it lets you put essentially a beneficiary on the deed. So let's say I own a condo and I own it myself, and I want to make sure that my spouse or partner or friend even gets it in the end. But I don't want to do a trust-based plan. I want a simple plan. I can then put that person as the beneficiary on the deed. I still own the condo. I can still sell it. I can still refinance it. I can do whatever I want to with it. It's just when I die, it goes to the person I've listed as the beneficiary. It is a very useful tool for people that want to have a probate avoidance plan that is kept pretty simple. There are some negatives to it. The main one being, main two being one, a lot of title companies will make you have the person that you've left it to sign off if you want to sell the house or you want to refinance the house. Also, if you change your mind, let's say you divorce that person or you split up from that person, some title companies will make them sign off on reverting the Lady Bird deed back. So it can be a little messy. So when I counsel people through whether a Lady Bird deed is appropriate, we just talk about who is the beneficiary, how likely are they going to remain a beneficiary. If it's to children, that's typically the easiest one, or a current spouse, that's typically pretty easy. But if it's just a friend or a partner that's fairly new, you know, obviously it ends up being that person's decision, but I, you counsel them on the negative aspects of it all. Um, and is Holden still here? Like, I'm not sure if there was another question more as to, um, I mean, to be honest, nobody knows. When I was preparing for today, talked to a lot of um, lawmakers that I know. Michelle Rayner Goolsbee, she's in the state legislature. Everyone has their own speculation about what could happen and what might happen. I think if if gay marriage is overturned, if you have a marriage from another state, I think blood on any of that because I told you I'm 0 for 1. So let me see. Oh, let me see. There's some other questions. There's a question. Considering eloping before the inauguration, should we consider eloping outside of Florida? So if you want, nothing is bulletproof, obviously, but if you want to have the most protection possible, I would get married in a state that has enshrined the ability to have a same-sex marriage. California, Colorado, for example, Washington, for example, Massachusetts, New York. Um, the the federal statute requires Florida to recognize those marriages, so you would be good there. If you got married in Florida, I still think you'd be good. I do. I think we're a ways out from anything significantly happening. But the safest thing that you would be is to get married in a state that has no chance of repealing same-sex marriage. And that's one of the problems, really, is because this really becomes those that can afford to go do things like this, same like with abortion, right? You can find a way to get to another state. But for those without means, this is where it really hurts our community. Is like some people can't afford to fly somewhere else and get married. And so it's going to be a significantly different impact for those with means than those without. Let's see. Does a ladybird deed also work for married couples? We want to leave ours to a nonprofit. Um, sure, it absolutely can. Absolutely can. Um, Okay, so Holden. So if marriage is sent to the states and Florida says it's illegal, what happens? Well, they can't. So let's say if Oberfell is overturned, then it goes back to the states, right? But we have the federal statute that says if you get married in a state that recognizes it, Florida has to accept it. So they can't deny marriage from another state. Um that's that's they just can't. Unless that law also is repealed. But please don't make me go down that what if. If that happens, we're all getting together and we are moving to another country, frankly. Um, Debbie says, how do you file a marriage that happened in another state? You don't file it, they just have to recognize it, meaning if Florida's a little different because we don't have Florida state taxes, but like if you have a state, if you had state taxes, they would have to recognize the marriage and being able to file jointly, that type of thing. And same thing with what I talked about earlier about tenants by the entirety. Well, my marriage was done in Colorado where it's recognized. You have to recognize it in Florida. Therefore, you have to recognize my tenants by the entirety. That would be my argument. There's no case law for all this yet. And by case law, what I mean is the courts haven't heard decisions and made precedent about anything yet. So we're all kind of flying by the seat of our pants. And we can only make educated guesses on what could happen and what we hope won't happen. Um, Great questions, everybody. We are going to post this. So if you know of anyone that didn't get a chance to come on, or you are on here with someone and you disagree about what you remember I said, you can always watch it again. Appreciate you sharing it too, getting all of this out. There is, I think the percentage last I saw was like 70% of same-sex couples are not married. So this is even more important for them so that we make sure that they can take care of their loved one. You just hate to see it. Just hate to see it so much when they didn't intend for it to happen. It was on their list to do, and something tragic happened. And now that surviving partner is just left out in the cold. That breaks all of our hearts, I'm sure. Um, Next question. If we build a plan, get all the documents we need, and move out of Florida, do we need a new set of documents from the new state? We're contemplating getting the heck out of Dodge. Paraphrase a little there for you. So the easy answer is no. As long as documents are executed, and by that I mean signed appropriately in the state in which they are created. So let's say you come to me, we do everything, we cross our I's, we dot our T's, the other way around, and you move to Ohio, for example. Ohio recognizes those documents and they will be enforced. The caveat to that is I always recommend you go talk to someone in your state. For example, when people move to Florida, we recommend that they update their documents because we have certain homestead and tax advantages that other states don't have. It's one of the few perks, right? Florida has now. I'm not familiar enough with Ohio. Now, California, you would most likely be recommended to update because California is a community property state. So it's different application of your marital assets, especially if you don't have a prenuptial agreement. Big fan of prenups, by the way, if you're contemplating getting married. Just a great way to make sure everything's clean in the event things don't work out. Not you, Susan and Chi. You're going to be great. I know it. Um, Anybody else? Well, like I said, I'm sticking around. So if you don't have anything else, you are free to go. But I am going to stay on just in case anyone has any um, secret questions they want to ask.
Liz, I have a quick question. This is Debbie. We're actually going to be on vacation in Seattle in July. I don't know if Washington is one of the states that has it enshrined. I'd have to look that up. We've been married in Florida for 8 years legally.
Hmm.
If we decided to just go file paperwork in one of those magical states, we don't really need to do anything later to prove that we've done that.
I don't know the answer to that because I don't know what it would look like. Like would now there be some sort of new law in Florida that says you have to file things in, quadruplicate just to make things difficult for us?
Hmm.
So I don't know. As of today, there's nothing anyone, heterosexual or otherwise, has to do when they move to a state to prove they're married. When
Right,
I've been married 8 years, I've never had to show my marriage certificate. So
right.
yeah, don't
I
yeah,
guess I'm just wondering if we should bother doing that once since we're going to be over there. But
I wouldn't.
okay.
Yeah,
All right. Thank
I
you.
would just enjoy your time over there.
Yeah. Thank you.
Yeah, it's gonna scan through these questions, make sure I haven't missed anyone. I don't think so. Oh, couple. Oh, prenups. So I don't do prenups, Bridge. I refer those to people because they are very legally specific. And if it's not your wheelhouse, you're probably doing someone a disservice. But all a prenup does is say, hey, I love you, you love me. I'm coming to the marriage with X, Y, and Z. You're coming to the marriage with A, B, and C. If we don't work out, I'm keeping my X, Y, and Z. You keep your A, B, and C. So my wife and I have a prenup. Our estate plans give each other everything. It doesn't prevent you from doing all of that. What it does is it says, hey, you know what? If things don't work out, because sometimes things don't work out, we get to go with our own marbles. We get to go with our own retirement plans. We get to go with all our things. And it's not messy, and it's less messy, I should say. So that's what a prenup's for. It's like it's agreeing to the rules of the game before things are impossible to make to where you can agree. Um, they're awkward. I can still remember we were on a walk together before we got married, and she broached the subject, and I don't know why I hadn't thought of it myself, but I hadn't, and I was a little taken aback. But once you think about it, it just makes sense. Um, and they typically what you do is one of you goes to one lawyer and one goes to the other lawyer, and the two lawyers agree on the language in the prenup. Um, so it's not inexpensive. I want to say it probably costs all total for us about 5 grand. I'm not saying it has to cost that much. I think we went to some pricey lawyers, but definitely important. Definitely one of those things you don't want to just pull off the internet. I'll tell you that. Yeah, you never plan on the divorce, right? But hopefully things will work out wonderfully. But it's always good to know that if something happens, you're protected, she's protected. So, anything else anyone wants to talk about? Remember, if you want me to zig or zag on something else, we've got about 14 more minutes before I've got to run to another appointment. Hey, that's awesome. Susan and she have been together for 27 years. I love one of the things I ask when I have clients come in is their origin story. And I once married these two men who I think they'd been together 70 years. They both were in their 90s. It was one of the best days of my working life. It was a joy. Love does win. Well, okay. Well, since we're recording this, I'm gonna cut it short here and stop the recording. Thanks everyone for coming. If you would like to do a consultation with me, you can email Vicky. She's on her email address is on the emails you get about lunch with Liz. It's Vicky at lizmoneymakerlaw.com. Or you can call if you're one of those few people that still like to talk on the telephone. Oh, thanks, Vicky. Vicky just put her email in the chat and our phone number. You can also go to our website. There's a contact me form there too, if that's easiest. Um, we are scheduling into January now, so I will see you in 2025 if you do decide to call and make an appointment. Otherwise, I wish you the best. If you see anybody, just make sure that they're talking to you about all of these things and they're not just a will mill, as we call them, and just charging you, 200 bucks for a will. That's doing you a disservice and just kicking you out the door. So, um, all right, Vicky, I'm going to stop the recording now. Thanks everyone for coming. I'm staying on though, again, just in case there's anyone that has a question. I do need to go right at one though. Welcome. Thanks for coming, everybody. And let's just pray. Let's just pray that this is all just irrational fear. I don't think it is, but let's pray that it is. So there are some people still on here. If you're still on and you want to talk, if maybe you could direct message me. Otherwise, I just think maybe you forgot to sign off or you walked away to get coffee and forgot that you were still on Zoom.